Hey everybody, this is Shawn Adams with ResolveIt. I want to thank you for joining us today. Today we're going to talk about the opposite side of the equation. If you need to sue somebody, what are the steps that you need to take to see this happen? Now, what a lot of people don't realize who are not lawyers or paralegals or law clerks or in the legal industry somehow, is that a case begins a lot earlier than the filing, than the going to court, than the hearing stuff. There's a whole sequence of events that happens before that. First off, you need to file your case, and you need to consider where you're going to initiate your case, because there's a whole bunch of courts, tribunals, processes that you can use to resolve your case. Civil Resolution Tribunal. They hear small claims matters $5,000 and under. If your case is more than that, you can ask them to just judge $5,000 and to top off the rest, as it were. There are some other choices. If you have a residential tenancy problem, or a problem with rent in arrears, or somebody not doing maintenance, somebody being too loud, you want to go to the residential tenancy branch, and they take care of all of the residential tenancies, not commercial tenancies. Those are a civil matter, but as far as residential tenancies go, they support that. You might want to consider the Supreme Court. Those are if you have more serious claims, much more serious claims. They also hear a lot of injunctions. They hear orders and things of that nature. You want to consider also whether this is a civil case, a criminal case, or a regulatory case. Those are three completely different cases, and they have completely different means of initiation. So you might want to do some legal research first before you file your case, so that there aren't any surprises down the road. Another thing you want to do is you want to consider, can I try alternate dispute resolution? And there are three methods under this: negotiation, mediation, and arbitration. These are some means that you can take to stop a problem, to resolve a problem, before it even gets to court in the first place. And you do this through negotiation, obviously speaking to the person. And usually you can get a lawyer to hear your case in mediation or arbitration. And in those cases, you actually bring forward legal principles. You bring forward your case, and an impartial arbitrator, it's called, sits and hears your case and then gives you recommendations. Now, a mediation is not legally binding much of the time. But like I said, arbitrations are legally binding. Mediations typically are not, unless you take it to court and get it filed, but that's another story. Do you have enough evidence to bring forward your case at all? You see this a lot on the courtroom TV shows, but it happens in real life a lot. So you need to consider whether you have enough evidence. Do you have enough witnesses? Do you have documents? Do you have electronic evidence? That needs to be filed in a very particular manner, and it's important to take that up with your lawyer or your paralegal or ResolveIt, as the case may be. Other things you might consider: recordings, closed caption TV, CCTV footage, otherwise known as video cameras. They're everywhere. They record everything. Some of them even have audio. So you might want to consider that as a piece of evidence so that you can fully justify the claim that you're bringing forward. Demonstratives, those are things that you would show in court. For example, if you have a map, you're in a traffic accident and you need a map, that would be a demonstrative. So you would want to draw out the map, or at the very least download and print the map from Google or from, I don't know, Yahoo Earth. I don't know, whatever is credible these days. I don't even know. The only one I know of is Google. I remember there was GeoPlanets. They had a map before, but they don't exist anymore. So technology moves too fast. But before you even serve the defendant, you need to have your evidence together to give to the court. And then the court will file it, do what's called seal it, which they will place the seal of the court or tribunal on those documents, or at least process them, and then give them to you so that you can serve them to the defendant. Can you afford the method that you're choosing for a lawsuit? There are some courts and tribunals that are more accessible for people that are in a more difficult life circumstance. For example, the Civil Resolution Tribunal, you can actually apply for a fee waiver, and then you pay absolutely nothing until your case is heard, and then there are some determinations made about who pays. You might want to consider lawyer fees. Can you afford a lawyer? Would it be better to get a paralegal? Can you find a legal advocate? Perhaps you have a case that involves human rights law. In those cases, there's a lot of amicus curiae, it's called, or friends of the court, who can join you in your case and help you advocate. And those people know the law, and a lot of them are lawyers, or at least legal advocates that are trained to perform the law. So you can get some free help, depending on the nature of your case. Again, it depends a lot. In law, you have to consider every situation separately. But at the end of the day, it's your responsibility as the plaintiff to bring the case forward. It's your responsibility to choose the right court. It's your responsibility to choose the evidence that's going to be advanced. It's all you. And that's the difficulty of being the plaintiff vis-a-vis the defendant, is that if you're the one bringing the claim forward, you have the most responsibility, other than the judge, for making sure that the facts are brought forward. It's essential to have all of the evidence down pat, to make sure you know the right place to put your claim, that you are doing ADR, that you are at least attempting to negotiate with the person. That actually bears very well on you when you go to court if you've made efforts to negotiate and the other party said, "Oh, I'm not going to listen to anything you say." That works in your favor. So try those methods. And as I said, do you have enough evidence? Can you afford your lawsuit method? Check your local laws. Your mileage may vary. So I hope that this has been helpful instruction as to the preliminary steps that you need to take when you're filing a claim as the plaintiff. We have a lot more videos on this channel giving you legal instruction about how to do things from both the plaintiff as well as the defendant perspective. Speaking of defendants, you may already be involved in a legal case and somebody has sued you, but you also have a claim against them. In that case, you want to file what's called a counterclaim, when that's going to be the subject of one of our next videos, probably the future video that comes out. Again, my name is Shawn Adams with ResolveIt. If you need to contact us for legal services, or if you just have a legal question that you'd like answered in another video, ResolveITCanada at protonmail.com. Until next time, share this video with somebody that needs it, and until next time, stay awesome, my friends.